Hey everyone, welcome back to the Irretrievable Breakdown podcast where we discuss all things divorce. I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and I am joined by my co-host and the managing partner of our firm, Nicole Bikakis. And today we are going to discuss discovery in Connecticut Family Court, so the exchange of financial information and other information so that you can have the information you need to try to negotiate your case and hopefully reach an agreement. So Nicole, we'll get into that shortly, but before we do so, how was your weekend? It was Father's Day weekend, so I hope you celebrated that with your husband Connor, and I hope you made it a very special weekend for him.
Every weekend is special for Connor.
Especially this weekend. Yes. What did you guys do?
He got to play some tennis. He did like a clinic with some other dads, and he got to go out for a lunch with just dads, so I feel like more and more on Mother's Day and Father's Day, we're sort of gifting our partners a day without the children. But he also got a lot of family time, a lot of kid time in. So
nice.
Thought it was a good day. How was your Father's Day? Now a father of two?
Yeah, but I want to know more about Connor's big day. So when was his day? Was it Sunday or was it earlier in the weekend or what?
Sunday. Yeah.
Gotcha.
Yeah. No, he got up, got gifts from the kids, got waffles, got to go play tennis.
Wow. Waffles in bed, or did he have to get out of bed to eat his waffles?
I don't like food in bed.
Yeah, neither do I, to be honest.
It attracts pests.
Yeah.
And honestly, syrup in bed doesn't work for me.
Yeah. My weekend was good. I had myself a day on Friday. That was like my me day. It was Juneteenth, so the office was closed. So I woke up, I went and played 18 holes of golf with some of my friends, and then I met another friend at a restaurant in New Haven and watched the USA World Cup soccer game. Oh. And then I went home, back to reality of parenting two young children. But
what restaurant?
Bear's Smokehouse. So like a barbecue place, got to hang out, saw some other people who I was not expecting to see there. So that was my day. I did that on Friday. I would have felt a little guilty, like just disappearing to the golf course on Father's Day, because as much as it's like called Father's Day, it's really not Father's Day because you have to, it's like Family Day.
Mm-hmm. Well, it's a day where we celebrate fathers and really acknowledge you guys and all the things you do.
Yeah. But there's a part of me that wants to be like, it's Father's Day. I can just go play golf and basically like disappear and do whatever I want. But then like not really being a good father if I'm like not spending it with my family.
And not to mention you have your own father. What'd you do for your dad?
He came over. So on yesterday, what did we do? We went to my brother's house in the morning, and then he was off to like sleepaway camp with his two kids to a hockey camp. So we went there in the morning and then went home in the afternoon and hung out in the backyard. I have like a projector set up outside. So we watched the US Open golf, and then we watched Toy Story on the projector.
Oh, that's nice.
A little bit of Toy Story, but the projector set up like not the greatest when it's during the day. I could like barely see anything, but it was nice to be outside.
Well, this time of year when the days are so long, which is really nice. Yeah. Probably not the best time for outdoor movie nights.
Yeah. Not exactly. So anyways, today we have to talk about discovery. And like it was I was talking with you before. It's like I hate talking about discovery. Like it's just so boring. Do we really have to talk about that? But the reality is like it's a necessary part of the divorce process. And you have to exchange financial information. You have to, get an understanding of what's going on before you can even get into negotiating a case and trying to reach an agreement. It can be very tedious and painful, but it's a necessary evil. Not that any of this is like fun going through the divorce process, but discovery can be particularly tedious and cumbersome.
I feel a lot of people feel that way. It's the clients feel that way too. No one likes to have to go through and gather their own discovery and then having to request your spouse's discovery and wait for that and then go through it. And then where you're noticing that there are certain records that are missing and having to deal with those issues. It's the clients don't enjoy the discovery process. The lawyers don't particularly enjoy it either. And most importantly, the judges do not enjoy the discovery process because they're only brought into it when the parties cannot figure the discovery issues out between themselves. So,
right. You're supposed to exchange the information kind of on your own. It's outside of the court. But when you kind of have a dispute about whether or not a certain document needs to be turned over or not, then it goes to the court. And yeah, the judges get annoyed because it's like, can't you guys figure this out on your own?
There are several steps that, someone doesn't comply with a discovery request. The court first gets involved, just say they compel you to respond. And then if that doesn't work and you guys can't work it out between yourselves, then they have to have a hearing on the discovery issues. And they hate that. Judges hate having to hear these discovery disputes. And so if you're before a judge on a hearing for discovery, that judge is already upset with you.
Yeah. So do your best to work out these discovery disputes whenever possible.
Right.
And a lot of people, they want to get into negotiating before the discovery process is complete. And you really can't do that. You sort of, just divorce is just dividing up a pie of assets and things like that. And you can't divide up a pie before you know how big the pie is or what it's made out of. So you need to go through the discovery process before you can start negotiating, particularly division of assets. You can sort of figure out custody issues before the discovery process is complete. But with asset division or alimony, it really doesn't make sense, generally speaking, to start those negotiations until you know what there is and you get that information through the discovery process.
And we do have a lot of clients who, even initially, they're anxious to get the process done with. So they're very tempted sometimes to say, I don't even want anything from the other side. I don't have to give my information. Can't we just settle this? And sometimes clients will get to the end of their divorce having said that they don't want to look into any additional discovery. They don't want to review these records. And then after the divorce goes through, they realize that there was something they weren't aware of, right? And then they have buyer's remorse. So it's the discovery phase. It's that information gathering part of the process. It's so important. You can't rush through it, and you just have to wait and do your due diligence and understand what is there and what isn't there that should be there and all the rest of it.
Right. So generally when a case is initiated, a lawyer will file a request for production. And there's the mandatory documents that are exchanged in almost all cases. And those are basic statements like tax returns, bank account statements, retirement account statements, mortgage statements. You can add a request for credit card statements, which is not part of the mandatory discovery, but you're almost always going to want that.
Pay stubs.
Right. Pay stubs to show what income is, W-2s, which are part of, those are often attached to the tax returns along with 1099s. And then,
retirement statements, appraisals.
Right. So if there are more complicated aspects to the divorce, maybe there's a trust. So you will want all of the trust documents, things like that. Or if somebody owns a business, you will want a lot of records relating to the business. But if you are seeking documents from the other side, you're filing a request for production, which lists all of the documents that you want. And, that will help you kind of get an understanding of the financial picture of your family so that you can begin the negotiating process, so that you can understand the totality of the assets that are on the table and the income that's involved for the purposes of negotiating alimony and child support. And then once you file that request for production, the other side has 60 days to comply, so to produce the documents or object to the request. And they'll object if they find it overly burdensome, that the documents are irrelevant, they have nothing to do with the divorce. So they have that 60-day period to either produce the documents or file an objection.
Although newsflash to most is that you can't really object to discovery that is reasonable to ask for. And what is reasonable is pretty broad to a judge. They would rather you exchange the information. And then if you can't come to an agreement and you have to go to trial, well, then there's a lot of information that can't make its way before the judge if there are hearsay concerns or, other limitations that wouldn't permit it to come before the judge. But in terms of what you can ask for from the other person, it's pretty broad. And then we also have, I'm sure we'll get into the depositions and what those are. But those are also a discovery tool, and judges will say you have to err on the side of providing the information that's being asked. Even if you think it's irrelevant, that's not really the standard for whether you produce discovery or not.
Right. But sometimes, things in discovery are objectionable because you'll unfortunately see lawyers kind of using it as a weapon sometimes of saying, like, let me see how annoying I can be and how burdensome of a request I can put out there to try to bring the other side to their knees, of like spending so much money on attorney's fees or just having to spend so much time on discovery that they will just cave to the demands of the other side.
Right. At a certain point, a judge will intervene and say that this is completely unnecessary. They've provided all this other information. This is not reasonably calculated to lead to the discovery of admissible evidence, which is one of the standards for, requesting documents and a basis to object to having to provide documentation. But I also think in practice, judges don't want to be dealing with these discovery objections. And so they will oftentimes say, just produce what's being asked unless it really is blatantly harassment. And
so what are some examples of when you see judges, saying you don't have to provide that? This is clearly just like, it's too much. They're asking for too much.
Right. So I think, if this is a divorce case and, let's call it like a 15-year marriage, and, they want you to provide all 15 years of bank statements and tax returns. You need to have a good reason to ask for 15 years of statements, because the mandatory discovery mandates 2 years. So if you're going back 15, and judges will go back more than the 2 years for sure, but they're not going to go back 15 years unless there's a very compelling reason as to why.
Right. Like evidence of, hiding, a history of hiding assets and moving them into some other account, and you need to keep going back to see when this behavior began. But usually, like, I don't know, anything beyond like 3, 4, 5 years, the judge is gonna be like, all right, come on. Like, they're not gonna go through. First of all, who knows if the bank will even have the records going back that far, but they're not going to require them to, provide that much by way of financial information.
Well, and that's the other thing to consider and understand too, is that you have to provide what you reasonably have access to. So now in this age where everything is paperless and you have access to your accounts, you can go onto your bank account, online bank account, and download your statements. So they're readily available to you. But if something is not readily available to you and you don't have it, it's not within your control, then you don't have an obligation to turn it over.
Right. If you have no way to get the statement, then obviously you can't turn it over. And that will usually result in a situation where rather than the other side is requesting documents from you, they will be subpoenaing third parties. So, they may subpoena your phone records, or they can subpoena your bank records if somebody's just taking forever to provide the documents, or they're failing to provide them, or they're saying, I can't get access to those documents, even though you probably can. That's another tool that lawyers and frankly self-represented individuals have, is if the other side is refusing to turn over certain information or they don't have access to that, then you can subpoena records. You might subpoena police records, so police reports. Nicole, what are some other types of documents that you often see being subpoenaed? Another one that comes to mind are records from the casino if somebody is doing a lot of gambling. But Nicole, what else gets subpoenaed?
Well, and I think those are also examples that, for example, take the police reports. If you don't have the police report, you don't have an obligation to go and get it to turn it over. The other side has just as much access to those police reports as you do. And so they can reasonably just go and get it themselves. And then same goes with phone records. Like no one's really, you have to go take certain steps to really ask your phone company to provide your phone records. And, it's often easier if you just do that yourself. But if you don't want to go do that, then the judge will have you sign an authorization and have the other side go and do that for you.
Right. Or if DCF's been involved in a case, so the Department of Children and Families, if there are accusations of abuse or neglect, then you might have to subpoena records from DCF because you can't otherwise obtain those documents without a subpoena.
And we've seen a lot of subpoenas being executed for bank records that the parties are just not providing. So going straight to the source instead of waiting for the other party to provide something that, if you have reason to believe, is incomplete, and they're just refusing to provide the complete document, then you can get a subpoena and go directly to the financial institution to get the records you are looking for.
Or if you think they're lying, so they only put on their financial affidavit the fact that they have accounts at like M&T Bank or Chase Bank, and you're like, I know they have a Bank of America account, then you can subpoena any records from Bank of America to see if they have any records from there. So if you're worried somebody's lying, a subpoena could be a good tool to use also.
However, that does kind of raise like an interesting point and sort of a difficult problem to navigate in a divorce, which is where you have a feeling that someone is not being completely forthcoming and that they are concealing assets, but you actually don't know where they bank, right? Where could these hidden assets be? Because it's one thing if they just have another account at the same bank they've already given you an account for. In that case, you can just do a subpoena to that banking institution and you'll pretty easily find, oh no, here's an account that was left off. But what if you don't have any knowledge as to what institution they are banking at? And so obviously if you have access to checking, savings accounts, and other statements that you can go through and kind of look at to see, have there been withdrawals or transfers to other accounts that haven't been produced. That's one way to figure it out, but it takes a lot of time, of your attorney's time, going through and really analyzing the records and then chasing down any accounts that have not been provided.
Right. So just going back to the mandatory discovery, those discovery documents that need to be turned over. Another one is just a financial affidavit. And that's sort of really the map of the family finances, where both sides have to fill out a document which shows their income, their expenses, and all of their assets and debts. So that will list all of the different accounts that an individual has so that you can have a general understanding of their finances. So beyond a request for production where you ask for those documents, you may also want to take the deposition of the opposing party or other third-party potential witnesses. And a deposition is where you sit down. Usually it's in a lawyer's office. It's not in a courtroom. And there is a stenographer there who is keeping a record of the conversation, and the stenographer will swear in the witness. So if you're taking somebody's deposition, all of their answers are under oath, and there is a transcript of everything that they are being asked and all of the answers. And a deposition is a good tool for, through discovery, getting more of an understanding of what is going on. So if you do the request for production, you will get a ton of documents, and you may have tons of questions about what is in those documents. So you may see transactions at a certain vendor, and you want to ask, like, who is this vendor? Why are you going to that person? Or you may see a ton of cash withdrawals, and you want to understand why they are withdrawing cash, or you are, somebody's pay. You want to learn more about their compensation. Can they expect to earn similar compensation in the future? There are a whole slew of things that you will want to ask to get a more comprehensive understanding of the financial picture of a divorce. And a deposition is the best tool to do that, which, where you can ask follow-up questions to give you more insight into all of the discovery documents that you receive. And a deposition can also prepare you for trial where, you have an understanding of what the other side's going to say. So you can assess the other side's credibility and whether or not they are lying. You can understand how they are going to present their case at trial. You'll often want to understand, all right, what is your perspective on the cause of the breakdown of the marriage? You want to know what they are going to say that you or your client have done that led to the breakdown of the marriage. You want to know if they, say your client's been very abusive or you've been very abusive. So it helps you prepare for trial, understand what everybody is going to say. It locks in testimony. So if at trial the other side changes their story, you can then bring that transcript back and say, you're telling me X happened on so-and-so a date, but if we go back to your deposition, isn't it true that you said that Y happened? And you can really kind of cut into their credibility with the judge if they are telling two different stories at trial and at their deposition. So that is how a deposition can be useful. And Nicole, what else do you have to add about depositions?
Well, I was just going to say, in addition, like you just mentioned, in addition to it being an important and valuable tool for understanding the financial picture and being able to ask the opposing party specific questions to understand the finances, it's also to understand non-financial pieces of the puzzle and the divorce and preparing you for trial, and also getting information to hopefully incentivize settlement. Because once we all know what's out there, what damaging information exists, or also whether perhaps there's a lack of any real damaging evidence, you can now assess whether it makes sense to take the case to trial or just get to an agreement.
Right. Usually after a deposition, everything's out on the table. You understand what's going on. People, you feel like you sort of have your day in court where you can speak your mind about the horrible things your spouse has done to you, or, just you can tell your story a little bit at a deposition. So hopefully that after that process is complete, people can feel a little more like they want to try to resolve their case.
Although I would caution anyone who is going into a deposition for the opportunity to be heard, because deposition is a tool for whoever is taking the deposition. It's a fact-gathering tool. If you are the one sitting for the deposition, you're being deposed, any information you give is going to potentially help the other side. So if you're sitting for a deposition, You're answering questions succinctly. You're not there to give your side of things. You're there to answer only the questions that are being asked of you. And you don't want to over indulge the typically the attorney that's taking the deposition with information, because again, that's only going to be information they take and put into their ammo box, and you're there to provide only the information that's being asked and nothing more.
Right. But the reality is, like, if the other side's any good, you're going to be telling your story. They're going to be asking questions that you will have to elaborate on, the cause of the breakdown of the marriage and things like that.
Yeah. But again, if you're getting your deposition taken, you're not winning that deposition. I think people go in thinking that I'm going to beat this deposition, I'm going to win it. There's no winning at a deposition. There's just not making your case worse.
Right. And it's also like not necessary. A lot of people will want their lawyer to be like really aggressive at a deposition. That's not particularly useful. You may want to be aggressive during trial and really cut into story and really, nitpick at their story. That is not the purpose of the deposition. It is not to be combative with the other side. It's to just gather information, and you do not want your lawyer to be combative with the other side during a deposition. That will be very counterproductive when the purpose is to try to get the other side to open up and provide information. If you're being combative, it's only going to lead to them closing off.
The other thing about depositions is that when you're the one sitting for the deposition, sometimes you're expecting your attorney who's there helping you defend the deposition to be constantly objecting. And the reality there is that's not going to be very helpful either, because if your attorney was to object or instruct you not to answer, and then that has to get brought before a judge. Again, judges are going to err on the side of inclusivity when it comes to depositions. You're allowed to ask questions that are not necessarily relevant. Of course, there is a point in time where they only have so many hours that they can depose you. And if they keep trying to extend the deposition over a course of many days, you can, of course, ask the judge to get and basically stop them from continuing to depose you endlessly. So it's not in the attorney who's taking depositions interest to waste their time on pointless questions just to embarrass you or get a rise out of you. But assuming that the attorney taking the deposition is not doing that, the standard for what is relevant and what can be asked at a deposition is very broad. So you just kind of have to sit there and answer the questions that are being asked of you. Again, if they are completely off base or truly objectionable, then your attorney will step in. But it's typically your attorney defending. They're doing some basic objections, but they're just letting the deposition take its course.
Yeah, objections are quite rare in depositions. Usually it's just if they're objecting to the form of the question. But it's not like trial where there's many more objections and the judge may find that you don't have to answer the question because of a certain objection and rule of evidence. Those rules of evidence, they're not applying during a deposition.
And also because with a deposition, the judge isn't going to see the whole transcript. They're only able to see parts of the transcript if it's being brought in to impeach you on the stand later at trial.
Right. Impeach meaning if you tell one thing at trial, which contradicts what you said in a deposition, the lawyer on the other side will bring in the deposition transcript to show the judge how you have changed your story. So beyond depositions, there are also interrogatories, and interrogatories are essentially written questions where the lawyer will write out a question that the other side has to answer in writing. And it's similar to a deposition, except it's a written question rather than you being asked on the fly. I don't love to do interrogatories. I'd rather take somebody's deposition because I can ask follow-up questions. I can really get a better understanding. But interrogatories are good when you want to make sure that the other side has time to answer it. Because a lot of times at a deposition, if the other person doesn't know, off the top of their head. They'll just say, I don't know, versus an interrogatory. You can't really, it's harder to say, I don't know. They have to like figure out what the answer is. So in that situation, it can be useful to use interrogatories, or if the case is just like so basic and you, as the lawyer or the opposing party, you just need to know a couple of things, you may just do interrogatories to learn what those things are rather than, taking the time and expense to take a deposition.
Well, also with interrogatories, sometimes their value is limited because the attorney who is going to essentially be drafting up the parties' responses to ensure that they are very, they only answering the specific question, and they're being presented in a way to kind of just limit the usefulness to the other side. They're heavily reviewed and edited by the person's attorney. So sometimes that limits their value. And where the interrogatory would really be calling for a very detailed narrative that is better suited for a deposition, that's an objection I've seen before, right? Where it's like, if you really want the information here, take their depo. An interrogatory is not the appropriate venue for this.
Right. And, you're not really going to be able to assess the other side's credibility through interrogatories in the same way that you would be able to in a deposition, because, somebody's lawyer will be reviewing all the answers, as Nicole said. So those are interrogatories. And the last major category of discovery are requests for admission. So that is basically a series of requests of the other side. So, you will say request or admit or deny the fact that you had a extramarital affair with so-and-so person. Admit or deny that you work at so-and-so job. Admit or deny that your income is so-and-so. Admit or deny that you spent $10,000 on a vacation with your significant other. So it's a series of questions, essentially asking that the other side admit or deny a certain thing. And the purpose of requests for admission are to narrow the issues at trial. So that answer to the request for admission is usually admissible at trial, where you can just give that to the judge and say, hey, this person already admitted that they had an affair. This person already admitted that they spent $10,000 on that affair. This person already admitted that they're working on this job and that this is their income. So it can really be a useful tool for narrowing the issues at trial and shortening a trial, essentially. It's a tool that is not used very often by Connecticut attorneys, but it can be quite helpful in streamlining trials. There was actually one judge who, notoriously in Middletown, he's no longer a judge, but he would basically make both sides do request for admission to ask a bunch of, have the lawyers file a request for admission, and then he would only allow a certain amount of time for testimony. Nicole, do you remember how long it was?
It was a specific number of minutes, and you couldn't go beyond that.
Right. It was probably like 2 hours or something, or 3. It was something like very short. And you would have these fairly complex cases that you were only given a day to complete the whole trial. So it was sort of wild, and you had to change the way that you practiced quite significantly. But I feel like that was the first time you really saw lawyers using requests for admission. And frankly, it streamlined things quite a bit and it made it more efficient. But just requests for admission are not generally how lawyers practice in Connecticut. They're just more used to having testimony and having somebody tell their story during a trial rather than saying, Judge, here's a request for admission. I don't even need to tell this story.
I mean, the reality, again, is that sometimes the requests for admission, they have to be extremely carefully drafted in order to elicit someone admitting something on a request for admission versus just denying it. Because if it's written in a way where they could get away with denying it, they're just going to deny it. So the drafting of the request for admission takes quite a bit of time to make sure they're drafted correctly. But back to your point, I think most judges in Connecticut, they will respect the fact that each person has a right to their day in court and to present the case they want to present. And the thing with requests for admission is they can be a very effective tool for just saving you time on presenting evidence on something that we all just agree is true, and we don't have to sit there and provide all this evidence of that to prove to the court and provide enough evidence that this actually happened. We'll just admit that it happened. But so it can be used effectively for that. However, it can also make it really choppy. You know, sometimes your trial, there's a narrative to it and there's a flow. And if you have to kind of cut and paste certain admissions in there, and it can sort of impact sort of the flow of the trial sometimes. And I think most judges, not this specific one we were discussing earlier, just allow people to have their day in court and take the time they need to present the evidence they have.
Right. I'd say the requests for admission are like best for the court system overall, because it reduces the amount of time that lawyers take of the court's time, which, you know, our court system is very backed up here in Connecticut, not as bad as some other states that Nicole and I have heard about recently, but it's very backed up. So if, you know, requests for admission can reduce the amount of time that we take from judges and court staff, that can be good. But the reality is, like, lawyers aren't so much thinking about that. It's really when that judge forced everybody to use requests for admission that they were actually used and trials were streamlined.
And to be clear, streamlined trials are also very good for parties, because you don't want to have to pay your lawyer their hourly rate to do additional days of trial when it's not necessary. But at a certain point, you want to also make sure you're getting all the evidence you need to get in. So there's a fine line between streamlining it and then basically shortchanging someone on their time before the court.
Right, exactly. So those are the basics on discovery here in Connecticut. I hope we didn't bore you too much. I find discovery to be somewhat boring, but maybe it's just the actual doing of the discovery versus talking about it. That is the most boring part. But Nicole, do you have any other wise words to add about discovery before we part ways here today?
Just that it is a necessary step. Take it seriously, be patient. And, you know, hopefully if you're behaving well and the other side is behaving well and you guys are being honest and transparent, you can actually get the discovery process done without that many issues. But it becomes very challenging when parties start to try and conceal information. And that's when you get into this whole mess involving objections and motions to compel and hearings on discovery. And those are what can really increase your respective attorney's fees and really drag out the process and put everyone on edge.
Well said.
Yeah.
All right. Well, that is going to do it for this week's episode of the Irretrievable Breakdown podcast. As usual, if you have any additional questions, you can contact our office, Dolan Divorce Lawyers. And if you are looking for representation in a divorce or family law case here in Connecticut, we would invite you to contact our office as well. Thanks for watching and have a good week.